Good afternoon. This is John Richardson speaking with you from Toronto, Canada. Today is Tuesday, May the 21st, 2024, and I am joined today by Laura Snyder, usually in Paris, and Karen Alpert, definitely in Australia. And today we are meeting to discuss number 16 of Laura Snyder's working paper series on citizenship taxation, all of which is available on the SEAT website. That's seatnow.org. And this one is, in a sense, a culmination of the previous 15, where we ask and discuss extraterritorial taxation number 16. Cook is right for revisiting. Well, this is going to be an interesting discussion. So, Laura, I understand that it's hot where you are today,
Yes, it is.
but you'll survive this.
I'll be all right.
And Karen, what's happening?
We're going into winter. It was a nice, cool night overnight, and it's a cool morning here.
Okay.
Wednesday morning here in Australia.
So the title, Cook is right for revisiting. Well, what if somebody were just listening to this podcast and not had the benefit of the previous 15? Laura, what's Cook anyway?
Well, we're talking about Cook v. Tate. It's a 1924 U.S. Supreme Court decision that today is considered to underpin everything we've been talking about, the U.S. extraterritorial tax system.
1924, that's fairly recent.
100 years ago.
100 years ago, what was the date that the decision was issued? I think it was in May 1924. Let's look it up.
Yeah, I'm not sure. Maybe it is.
Well, hang on. We'll take 1 second to figure this out. All right, here we go. Cook versus Tate. Okay. So we have a decision here. U.S. Supreme Court. It's argued April 15th, 1924, and it's decided May 5th, 1924. So, oh my God, we have just passed the 100-year anniversary.
Yeah, we didn't have a party.
Well, absolutely. I mean, this is an old decision. I mean, do you think that the fact that it's so old sort of reinforces its importance, its validity, and the necessity to abide by it? Laura, what do you think about that?
I would say the opposite is true, John.
You're kidding me. Karen?
Not at all.
I think the world's changed a little bit since 1924. And a lot of the things that underpin the reasoning for the Cook decision have changed as well.
So you don't think that it makes any sense to kind of look at Cook versus Tate and say, well, by God, we have a case from 1924 and it's right, just, and equitable that whatever reasoning in there in that case should apply today. You don't think that's a reasonable thing?
No, the world's moved on.
Well, that's interesting. I mean,
there's a lot of other things that we've changed our views about in the past 100 years.
That is true. That is true. I mean, certainly a lot has changed. Laura, why don't you help us by giving a summary of, if this were a law school class, the professor would say, Ms. Snyder, the facts in Cook versus Tate.
The facts in Cook versus Tate. Well, let's see. What you had is an American living in Mexico who objected to, he had Mexican source income. Maybe he had a business of some kind. Can't remember exactly what it was. He had Mexican source income and he objected to the United States taxing him on his Mexican source income, given he didn't live in the United States, but in Mexico. And the case went to the Supreme Court, and the Supreme Court basically said, well, because you're a citizen, your citizenship benefits you wherever you are, and so you should have to pay your tax. And you might quibble with my summary there, John, but that's essentially my summary. It's a very short decision.
Well, it's also a very short summary. Actually, first of all, Ms. Snyder, who was the judge in Cook versus Tate? Who was the judge?
See, you remember these details about Cook better than I do. Was it McKenna?
You are right. You are right. Okay, it was. It was Justice McKenna. And do you remember much about Justice McKenna?
You do, John. Tell us about McKenna.
Well, McKenna was a very interesting guy. Of course, it wasn't common for people necessarily to go to law school during those years. And, these Supreme Court appointments were, possibly even more political than they are today. But, the good thing about Justice McKenna was that he was appointed to the Supreme Court and then he went to law school between his, being appointed to the Supreme Court and his actually becoming a member of the court. That's pretty impressive, don't you think?
Sure. Yeah.
I mean, he made an effort to prepare himself for the job. But, one of the problems, with Justice McKenna was that I've always found this very interesting, was that he'd had a major, major stroke during his time on the court. And by the time he wrote the decision in Cook versus Tate, he'd had the stroke and all indications are that he hadn't completely recovered. I have no idea what impact, if any, that may have had on the reasoning, because I think we have to, if we're going to evaluate this stuff at all, I think we have to evaluate it in the context of the day, right? Where I think, in fairness, there were very different ideas about citizenship and different ideas about taxation and everything. But, one wonders. And then, of course, he left the court not soon thereafter on, not the greatest terms. But I think it's hard to make a case that, Cook versus Tate was one of the better Supreme Court decisions of all time. But what did you think of the reasoning in Cook versus Tate? I mean, how did this guy go about ultimately what he did was said, the U.S. can tax this guy who doesn't live in the United States on his non-U.S. source income, even because he's a U.S. citizen, right? Ultimately, that's what was decided. But how did this guy get there anyway?
John, you would remember that better than me. You tell me.
Karen, have you read the case at all? Or?
It's been a while. My impression, and you can correct me if I'm wrong, is his main thrust seems to be that if you're a citizen, you're being protected by the U.S. and you get benefits from being a citizen. Therefore, you might as well pay for being a citizen. Subject to the same.
There was a guy, what was his name? Levitt, who wrote an article approving this decision. It was published, I think, 1920 something. This guy Levitt was a professor at one of the law schools, Virginia, I want to say, and later he actually ran for the U.S. Senate. So it gives you an idea of, his mindset. But anyway, this guy wrote an article approving Cook v. Tate, and basically you could read in him kind of, Blackstone, and who was the other guy who wrote about citizenship and how citizenship is, they wrote about, how you have allegiance to your country, and, with allegiance comes all of these duties. And that was the mindset that at least, those that approved of this decision had, that, as a citizen of this country, citizenship is not a nexus of rights. It's a nexus of obligation. And, you're a citizen, your obligation is to pay your tax. It doesn't matter where you live in the world. That was the idea. But I think the point with this 16th paper here is not to get into, what was the Cook decision exactly and, all of that. But it's basically to say that the world has changed a lot since the Cook decision. And this 16th paper has a timeline on 3 different subjects: how U.S. taxation has changed, how the concept of citizenship has changed, and how we understand equal protection and due process has changed. So all of those have dramatically changed since Cook v. Tate was decided. In 1924, the tax system was much more simple. Because of the thresholds, a lot of people weren't subject to it. In the 1924, our idea of citizenship was more restricted. Dual citizenship was extremely rare. A lot of people, when they left the United States for an extended period of time, especially women, automatically lost their U.S. citizenship. And also, your idea of equal protection was completely different. Cook v. Tate was decided in the wake of Plessy v. Ferguson. So you can see that, our modern conception of what is equal protection of the law has nothing to do with what people thought about it in 1924. And that's the point of this 16 paper is to show you can say things have dramatically changed. And it's true. But if you want to know exactly what's behind that, you can open up the 35 pages of this paper and you can see practically year by year since 1924 and before, just how those three things have changed progressively.
Okay. I think that's absolutely right. On the issue of citizenship, I mean, we've talked around this before. I have never read Cook versus Tate to be a decision about taxation at all. I've always read it to be more a decision about citizenship. And really, although it's not stated this way, the fact that the U.S. has essentially a property interest in its citizens, right, as an aspect of sort of, foreign relations, et cetera. And therefore, the very notion that, the United States could, that there were restrictions on how the United States could treat its citizens, I think was, frankly, almost unheard of at that point. Would you agree with that?
Yes, you still have this idea of people being subjects. You might throw around the word citizen, but how people understood it to be, or at least those in power understood it to be, was a subjectship. As I said, it carries obligations, not rights. We don't have this modern concept of citizenship until really World War II, with the Universal Declaration of Human Rights, et cetera, and all the things that happened in the aftermath of World War II.
But, the United States, I mean, I'll throw this out and you can agree or disagree. I think we've talked about this before, has really never embraced the idea of citizenship as being something beyond a subjectship. You agree with that?
Well, given how we don't think that, the United States won't enforce rights that are present in human rights instruments. They're not considered enforceable. So, and that's where to a large extent, that's where those lie. I think that under the Warren Court, I think, the court did try to chip away at what you're saying, and certainly in protecting people's right to keep their citizenship. But of course, for the most part, you're right. And I think even today, when you ask most people on the street, even what their concept of citizenship is, they will emphasize the obligations before they'll emphasize the rights, for sure. You're a taxpayer.
Yeah, you're a taxpayer. And that. I mean, what would you think somebody would point to today if you were to say, well, what would be a right of citizenship, of U.S. citizenship? What does it give you? What would be your answer to that?
Well, there's lots of things. I mean, I'd almost wonder in what context are you asking that question so that I could be more focused in my answer. Citizenship gives you the right to be present in that country, the right to enter it, the right to be present in that country, the right to be employed, to work in that country, the right to vote. I suppose the right to, most cases, for your children to inherit your citizenship. Those, the right to probably hold certain jobs. What else? I'm sure I'm missing a lot out, but that's what comes to mind first of all.
Consular support is the one I'd add to that.
Okay.
Are you aware there's not a constitutional right to vote?
Well, yes, of course you can get into all of that, John. But if you're not a citizen, you sure as heck don't have the right to vote.
Okay. So those are the things that citizenship gives you in terms of sort of positive benefits. Maybe moving to the tax side. Karen, can you take us through how the whole tax situation has evolved since 1924?
But in terms of how everything's become a little more complex. And I don't know the exact.
There's 35 pages in this paper answering that question. That's a heck of a thing to ask, Karen.
Yeah, I don't know the exact size of the Internal Revenue Code in 1924, but it's probably less than 1% of the size of the Internal Revenue Code now.
Would you say, as a general principle, though, that in 1924 the Revenue Code was much more about raising revenue than perhaps it is today?
There was probably a lot less of the social engineering that they've put in to the tax code. Yeah, the redistribution of income through various credits, etc., that you have today. You had, in
Was there
1924, you had to really earn a fair whack of income before you were subject. The thresholds in current dollars were much higher than they are now.
Do you perceive there to be, incredible hostility towards foreign income assets and that in 1920?
Absolutely. Ever since probably the 60s, that's come in with controlled foreign corporation rules in the early 60s, and then later the rules about, FBAR rules in the early 70s, then these foreign trusts, passive foreign investment companies, all these things, anything foreign must be a way to get around the US tax code. And it's just added a ton of complexity to the tax code.
So one thing that has changed from a tax perspective considerably since 1924 has been the attitude of the U.S. tax code toward all things foreign. You would agree with that?
I would definitely agree with that.
Well, that's what if you look at this paper number 16, if you really look at it, you can't not see that. Before the 1960s, the U.S. tax code did not go out of its way to, or even at all, penalize foreign things, specifically, isolate foreign income that's not U.S. source and penalize it in some way. And then in the 1960s, and treat it differently, which means penalizing it. And it's in the 1960s, but then on a sustained basis since the early 60s, that you see foreign non-U.S. source income being penalized, treated differently and penalized. And in almost all cases, maybe even all, the purpose for any of that was not to raise revenue. The purpose was to discourage people from from investing outside the country and having foreign source income. It's not about revenue. It's not about collecting revenue.
There's always this suspicion that people are buying outside of the U.S., investing outside of the U.S. to avoid U.S. taxes. So we want to make sure that there's no way you can invest outside the U.S. and avoid U.S. taxes. In fact, we're going to make it more difficult for you to invest outside the U.S. so that you direct your investment dollars domestically rather than outside the U.S.
But I mean, I don't know if that's ever reasonable, but it seems to me particularly unreasonable with respect to Americans abroad, right?
Well, if you're going to tax people who live outside of your country on their worldwide income, they're going to have income that's not domestic. And so you shouldn't be treating that non-domestic income any differently. Because for them, it's local, but, it's just not American or U.S. income.
So, Laura, would it be fair to say that when Cook versus Tate was argued, it was absolutely not the same context as today from a tax point of view, citizenship point of view? Was there
and an equal protection point of view had nothing to do. The tax situation was completely different. The citizenship situation was completely different. The equal protection situation was completely different.
When did the sort of, body of equal protection law begin on this? I mean, you say that it wasn't a factor in 1924. When did equal protection start to be a factor in U.S. law?
Well, it was a factor, but in a negative sense in 1924, because in 1896 was the Plessy v. Ferguson decision. And that's the decision where the court held that racial segregation on railroad cars was permissible under the separate but equal doctrine. And the court in that case said that the only limits that the legislature can exercise the only limits on the legislature in the exercise of its power was that the laws be enacted in good faith for the promotion of the public good and not for the annoyance or oppression of a particular class. And that basically is an extremely loose standard that more or less lets Congress do anything it wants. And so where you see equal protection coming, changing and how we understand equal protection today beginning to change was 1938. So 14 years after Cook in the United States versus Caroline Products Company. And that's the case where you have the famous footnote 4 that introduces the principle of levels of scrutiny, including strict scrutiny, when a court's considering the constitutionality of a law. So footnote 4 established the need for increased scrutiny of laws that affect certain groups, and notably groups subject to prejudice as discrete and insular minorities, rendering them politically powerless. So that's where you start to see things change. And then over the course of the 40s and 50s, you see a lot more change. You see in Hirabashi v. United States in 1943, the court says distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded on the doctrine of equality. And then you have a few more decisions basically saying that it's a violation of equal protection to discriminate based on nationality, based on national origin. You have Bowling v. Sharp in 1954, which held that basically it's federal laws that have to conform to equal protection and not just state laws. So you have a progression that happens. And then you have these are cases we've talked about in previous podcasts. You have the cases in the 60s under the Warren Court to protect citizenship, which are also equal protection cases. Snyder v. Rusk, Afron. So there you go.
All right, so would it be fair to say that in 1924, I mean, if you were the lawyer for Cook, right, that you would not have had in 1924 this sort of body of equal protection law available?
You would not have a single word of it available. You would be under Plessy v. Ferguson. You would be at a complete disadvantage.
So in other words, separate but equal. So under Plessy versus Ferguson, Congress could have actually enacted a law with the following language: all resident Americans will pay tax on interest income at 10%, but all Americans abroad will pay tax on interest at 20%. That would have been perfectly acceptable under Plessy v. Ferguson, right?
Probably.
Okay. All right. So that's interesting that if Cook versus Tate were re-argued today, then what I'm inferring is that equal protection would play a major role in the discussion, correct?
It should. Well, if people were in good faith, it definitely should. Because I'm sure that there were people who would argue and say, well, this is not about equal protection. Or, they would say it would be a different level of strict scrutiny, or a different level of scrutiny, because what you have today, the way the court has interpreted and has applied equal protection measures is they've said there are 3 different levels of scrutiny. The highest level of scrutiny, strict scrutiny, which is where more than likely the law will be struck down, is something that discriminates on the basis of race or national origin. And so I think most people, when they
race, national origin,
and alienage, yes, And I think most people, when they are first introduced to the suggestion that what's going on here is discrimination based on nationality, probably will initially resist that because, how can that be? How can the United States be discriminating against Americans and nationality? You don't usually associate American, but if you think about it, that's clearly what's going on. American U.S. citizenship, Americans, is a nationality, and we are being discriminated against among all of the people who live outside the United States. So, yes, if people are acting in good faith, clearly the decision would have to be different. Now, as we know, there's a lot of people who don't act in good faith.
Well, okay. So my understanding of this is that assuming that you get your foot in the door and you say, well, this is discrimination based on nationality and therefore strict scrutiny is the proper standard. What does that mean practically? Who has to prove what?
Well, if you show that there is discrimination based on nationality, then it's the government has to show that the measures are tailored. What are the words? That they're necessary to achieve their purpose, and they're tailored.
Right? And they do it in the least.
Sorry.
And they do it in the least restrictive way, or something like that.
Yes, they have to be tailored to only fill that purpose. They can't be broader than they need to be. You have to have a legitimate purpose, first of all. And that's right. And it has to be tailored to actually fulfill that purpose.
I thought the test was a compelling purpose.
Yeah, I think you're right. Compelling. Yeah, sorry, I don't have the language handy.
Oh, that's okay.
But yes, I think you're right.
I mean, it's interesting to hear you think you're, reason through this. It's very, very interesting. But let's pause here for a minute and bring Karen into the conversation. Karen, your background is in tax.
Unfortunately.
Tax has been important in your life, right?
Yeah.
Okay. Don't you think that tax laws are, because tax laws are, sort of reflect, how a country operates. I mean, don't you think that tax laws, by their very nature, serve a compelling government interest?
No, I think, a basic tax law, we're going to collect X percent of income and the government needs the revenue. Yeah. But when you start differentiating between types of income from, foreign versus domestic, and you have a compelling interest to collect revenue from your residents, but, and on income, or to collect revenue on income that's sourced within your country. But I'm not sure you have a compelling interest to collect revenue on non-U.S. income that's earned by non-U.S. residents.
I would go further than that, though.
Sorry?
I would go a little further than that, though. I think, John, where you're going with that is, are you saying that any tax law is by nature, yes, is by nature compelling, and so it's fine, and it should withstand any equal protection challenge? And in that...
No, I'm not. I am not at all. Okay. I am just trying to tease out, how the argument should work here a little bit, because, the reality, Laura, is this, okay? That, presumably my view is that right now we're talking about the Constitution, the 14th Amendment, et cetera. But my view is that it's the Internal Revenue Code that's the Constitution, right? That operates sort of outside all this stuff. Now, I like your arguments, and I think these are important arguments that, equal protection and, this sort of stuff should apply to tax laws, right? But the position, I think, of most academics, most certainly Treasury officials, et cetera, is that, there's a saying that some things are priceless. For everything else, there's MasterCard. And I think that the view of a lot of these people is the tax code cannot be scrutinized. For everything else, we have the Constitution. All right. And I think that this is a big part of the problem here, because we have the, like the anti-injunction laws, et cetera. And, Monty Silver's been up against this stuff, in his litigation for years, right? This whole idea that if it's a tax law, that it's not, basically there's nothing you can do about it, sort of thing, right? That somehow tax laws exist in rarefied air. So I guess my question to you is, what do you need to do to make the argument that tax laws are susceptible to constitutional challenge, human rights laws, all of these things that other kinds of laws are? How do you do that? I mean, you would agree with me, presumably, that the U.S. has very little cultural consciousness of human rights generally, let alone tax rights.
Sure, even little consciousness of constitutional rights. But, well, I would have a remark about what you said before answering the larger question. I was saying before that some people might have trouble with the understanding to what extent the current laws discriminate on the basis of nationality. I would say, would you accept a law that says that, African Americans will be taxed differently than people who are not African Americans? Would you accept and would be taxed more punitively or not? Would you accept a law that said that women will be taxed differently than men? Would you accept a law that said, I don't know, any type of person who's different from some other type of person? Native Americans are going to be taxed differently, or people who are Polish are going to be taxed differently. Of course, all that sounds absurd, but for some reason, it's acceptable to tax Americans who live outside the country differently. There's no difference. But
they're hated. That's the difference. I mean, Americans abroad. I mean, remember now, you made the point, and all of
that's why you need these protections. That's exactly why these protections exist.
Laura,
to protect people who are in the minority, who are hated, because otherwise you would not adopt the laws that punish them if they weren't hated. If they weren't hated, you would not be punishing them.
Laura, you referred a few minutes ago to the Carolyn Products footnote. Now, I'm going to ask you a very simple question. Would you say, to paraphrase Justice Stone, that Americans abroad are a discrete and insolent minority deserving of special judicial solicitude?
Yes, obviously.
Karen,
obviously.
What do you think?
Oh, sure. I mean, it's certainly distinct, and they shouldn't be discriminated against.
Even if everybody in America hates them and thinks they're a bunch of wealthy tax evaders.
This is the whole purpose of having a constitution, is to make sure minorities are not persecuted.
That's such a revolutionary thought. That's amazing. Laura, have you seen the movie about Ruth Bader Ginsburg on the basis of sex? Have you seen the movie?
I have not.
You haven't had time writing too many articles, right?
That's right.
All right. But you have to take some time out from your articles and see this, because this is actually a great movie. And honestly, I think that part of what we're talking about here is how do you extend concepts of equal protection into new areas, right? And I think that the extension of equal protection into tax is, would be regarded as a new area. But what I'm assuming the accuracy of the movie, all right, the first case, right, where she was successful was actually, it wasn't a tax case, but it was some kind of a disability benefit case, right? That was administered by the Internal Revenue Code, where, basically a man was denied a benefit that a woman would have gotten, right? So I think there's actually a lot in that movie, interestingly, about how to extend. I mean, anybody can use an equal protection argument effectively in a context where it's already been used, right? The question is how to use this stuff in an entirely different context.
Well, I'm trying to remember which case it was, but one of the cases that I talk about in these articles did have a tax impetus to it. I think what was going on was might have been the case you were just talking about. I think it was a case it was getting a tax deduction. Certain people got a tax deduction. I'd have to look it up again. But I don't think it's as novel as you are claiming it to be. You have seen equal protection decisions in a tax context. Definitely have seen that before. There might not be a million such. I think it was one of the gay marriage cases. I think someone was allowed, a marriage deduction, a deduction or some sort of tax benefit because they were married, and someone, they claimed it. A couple claimed it even though their marriage wasn't recognized. I'd have to go back and look at it. But I don't think that tax and equal protection have been completely divorced from each other in all previous cases.
Well,
I
that's
think
very encouraging.
answering your larger question, which I haven't answered yet, you said, shouldn't something along the lines of, shouldn't the taxes are so important? Shouldn't the tax code prevail over equal protection? How can we, when can you assert equal protection in a tax case? And I would say, if you're looking at it in that way, the danger here is that if you follow, these ideas of, well, taxes are always legitimate and the government always has a compelling reason to collect taxes. And so, your equal protection claims should be less relevant, should not take precedence. I would say the answer to that is, then you can channel every single violation of equal protection that you want through the tax code, and you are safe. You will be able to do it. And what will happen then is what you have said has already happened, John, which is our Constitution today is the tax code. And that whatever rights we have under or supposed to have under the Constitution are irrelevant to the extent they are confronted with any sort of tax question. That's a very dangerous world that I would hope everyone would want to resist in some way.
I think it's important to recognize, though, the extent to, which I think the perception is that we in fact are there. But let's look at it this way. Doesn't the fact, here's what I really think, right? The fact that taxation is so important, the fact that taxation is the organizing principle for society, the fact that tax laws create opportunities for certain groups and deny opportunities for other groups, the fact that taxation is no longer even about taxation, but awarding benefits and punishing people is, I think, the argument for why equal protection should apply to this stuff front and center. Because otherwise, what you've got is a political majority that could basically tax the minority right out of existence. What's to prevent the Democrats from winning the election and just raising the taxes for all Republicans?
But that's the problem.
Well, that's
exactly the problem.
That's why equal protection should apply, unless sort of political affiliation is not a suspect class. But I don't know. It's a huge problem, and it's clear that there's a long way to go. But it seems to me that,
look, guys, I'm going to have to call it. I forgot that I had something. I have to leave now.
Okay.
I've got an appointment in 45 minutes in the city, so I've got to get going.
Okay. Final thoughts on this?
Sorry about that. No final thoughts. I'll let you guys continue.
Bye, Karen.
Okay, thanks. So what you're really saying here is, right, that we've got, sort of a three-headed monster, right, that can be unleashed on Treasury, the U.S. government, et cetera. One head is the equal protection. Second is the evolution of citizenship. And actually on the issue, and the third is, of course, the evolution of taxation. But let's talk a little bit about the evolution of citizenship, because that has a constitutional dimension to it that did not exist in 1924. Agreed?
Yeah, of course. Yeah.
And how would you describe the difference?
Well, we've talked about this in prior podcasts, and we talked about it a little bit earlier in this podcast. So in 1924, I think most people still had what you would consider a very old concept of citizenship. Even though the word citizen might have been used, people still thought about it in terms of subjectship. And what does that mean? That means that you belong to a sovereign, and that sovereign has rights over you. You have obligations to that sovereign, but you don't have a lot of rights yourself. And that sovereign doesn't have a lot of obligations towards you. And certainly this is how people thought about subjectship/citizenship at that time. And again, it's not until World War II, with all the abuses of people and using citizenship to abuse people, it was so not until after World War II, with the adoption of the Universal Declaration of Human Rights and other international human rights instruments, with the evolution of concept of citizenship by the U.S. Supreme Court, that you finally see changes to that. And you finally see that, okay, citizenship is a way, and in many ways, the only way for people to have any rights at all. You have, Hannah Arendt saying citizenship is the right to have rights. You see Chief Justice Earl Warren repeating that in one of his decisions on citizenship. And so that's where you have, today citizenship is a human, it's a constitutional right to be a citizen of the United States. It's a human right to have a citizenship. You're not meant to be, it's a constitutional right that Congress cannot take actions to take your citizenship away from you. Certainly it could have before this series of Supreme Court decisions. So to get an understanding of exactly how that has evolved, I would refer people back to this paper number 16, which shows you exactly year by year how the concept of citizenship has changed from before Cook v. Tate up until the present day. But in a nutshell, if I had to put it in a nutshell, the prior concept of citizenship was a nexus of obligations. Today, it is a nexus of rights.
Okay. So the first point you make is going back that we have the equal protection weapon now. Okay, if I can put it that way, as a general principle, the equal protection weapon. So even if citizenship did not have the constitutional status that it does now, we'd still have the equal protection arguments to attack citizenship taxation, correct?
Of course.
Secondly, though, and independently, the constitutionalization of citizenship from the Warren Court, and of course, culminating, I suppose, in the Forum, versus Rusk, right, gives citizenship a special status, a certain constitutional status that's independent of equal protection. Agree?
Yes. Well, its ultimate source constitutionally would be, isn't that also the 14th Amendment that says that, everyone who's born in the United States is a citizen?
Amendment.
Yeah, a different part of the 14th Amendment from the Equal Protection Clause. That's the ultimate source. But you see the Supreme Court relying on that in their decisions in the 50s and 60s.
Okay, so a clear evolution from 1924, Cook versus Tate. And then moving to the third thing, that the whole nature of taxation has changed completely. There's no relationship whatsoever between what tax meant in 1924 and what it means 100 years later in 2024, right?
It means, yes, it's completely different.
So would you say that if you were re-arguing a Cook versus Tate case, do you think Cook versus Tate is even relevant to the argument?
No, that's the entire point I'm trying to make. It's irrelevant.
Completely irrelevant.
Yeah, well, people will say that it's relevant. They still do. You still see people saying ever since Cook v. Tate has decided that, the citizenship-based taxation is constitutional. And they don't question that. And then they, keep going. But
government lawyer wanting to defend the constitutionality of citizenship taxation, how would you use Cook versus Tate? Would it be restricted? Well, the court's already ruled this.
Yeah. I mean, for sure, that'd be one of your first arguments. This has been decided already.
Is there an argument beyond that?
You tell me.
I think the answer is no. Unless it's just sort of some stare decisis type of thing. That's it. The Supreme Court should be reluctant to overturn a 100-year-old Supreme Court decision. The older these decisions are, they're like fine wine, the better they get. I mean, I don't see any argument at all. I don't even see what, at this point, honestly, what Cook versus Tate has to do with the issue at all. I mean, I don't even see it as a tax case. I think that it's a case about the meaning of citizenship where tax is used as the example, but I don't think taxation is really the issue in terms of what the case actually meant. But that's just my view of it. All right, so Laura, I think we agree that Cook versus Tate is best thing you can say about it is that it's sort of a historical curiosity written by a judge who hadn't been to law school after he had a serious stroke comparing his judgment. I mean, I think that's the kindest thing you could say about it, really. But Was it you who told me that it's still taught in law schools? In law school tax classes? Did you tell me that?
Okay, this is not only repeated in law school material. Yeah, yeah. Even, things published last year, this year, any discussion of how overseas Americans are taxed will, within the first few paragraphs, talk about Cook v. Tate. Yes. And in law review articles that are on this topic, even by people who don't support this system, will cite Cook v. Tate to say that it's constitutional. No one questions it. No one questions it.
And I don't understand why that would be. What, help me. Why is that? Why does nobody question it?
Got me.
Well, there must be. I'm serious. There must be some. I mean, can people really be this stupid? I mean, it reminds me very much of, was it, I can't remember what the name of the case, the Supreme Court recently, ruled that there was no constitutional right to abortion. So all of a sudden, we find out that all these states have 100-year-old laws prohibiting abortion. And, to my utter amazement, a lot of them took the position that these laws, somehow were in effect now. So I don't know, maybe it's America's obsession with law, and the older the better. I don't know. But it's madness. It's crazy.
I would imagine if you were an academic and you've seen all of your colleagues never question this, you might be uncomfortable questioning it yourself. You're questioning your colleague.
So are you saying that you think it's just sort of, the gospel according to Club Tax Prof?
Oh, definitely that.
They like it?
Definitely. Do I like it?
They like it.
Did they?
They like it, Club Tax Prof? They like citizenship taxation? Or
yes.
Versus Tate?
They do. No, they love it. They love it because they hate us. We're all tax avoiders, wealthy tax avoiders.
Laura, you're talking as though you're a discreet and insular minority, which means that you must be deserving of special judicial solicitude.
So the footnote talked about, groups subject to prejudice as discrete insular minorities, rendering them politically powerless. I think we definitely fall into this.
I think that's definitely true. I think that Americans abroad are walking, living, breathing examples of violations of equal protection. Do you agree?
Definitely.
Well, Laura, you were brought into this world for one reason, and that is to educate the world on that, which I think, you're doing a very good job on with all your writing and all your articles. It's good stuff, Laura.
Thank you, John. Yeah, thanks for... Well, you do a lot of good stuff, too.
Well, I didn't write working paper 16 about Cook versus Tate. Laura, that may go down in history as the 21st century of Martin Luther's, banging the... You think?
Okay, yeah.
All right. On that note, any final comments, thoughts?
Well, this is the last one of our series. So I hope people have a look at them. I hope, share them. I hope they're helpful. And thank you, John, for the chance to talk about them.
Oh, my pleasure. These conversations have been a lot of fun. Well, I hope that people download them. But as I say, I think that these are likely to become increasingly important over time because, once there's sort of an acceptance that this is an issue worth looking at, where are they going to look?
Hopefully. You never know, but hopefully. I did just write an article about how we're invisible.
Invisible? What do you mean by...
means, well, we'll talk about it in another discussion, but basically the article says that the contributions to knowledge of Americans who live outside the country are basically belittled and ignored. And I don't see that changing anytime soon.
Laura, I've never in my life seen anybody do so much work, so much effort, so much wonderful stuff, and yet be so negative at the same time. Laura, the only thing we're betting on is time. There's no question that this will change. As I can't remember who said this, okay, but maybe we close with, what is it? The moral arc of the universe is long, but it bends towards justice or something like that. Who said
I
that?
think, yes. Isn't that Martin Luther King Jr., I believe?
I think so.
Could-
I think so. And then Barack Obama tried to get away with using it. All right.
All right.
Great stuff.
Thanks, John.
Thank you.